Hi, everybody. I know some of you in person. I've met some of you in person, but thank you so much for joining us here today. I know it's a really serious topic and it brings a lot of emotions in people, but I really want to kind of share my knowledge about estate planning and succession, business succession planning, since we're all business owners and I just get a lot of questions about things like that. So I prepared a little presentation that's going to talk about estate and legacy planning for business owners specifically. And so, as Sharon mentioned, I am a co-founder of Legacy Law Group. We're an estate and business planning law firm in Colorado. And I'm also a mom of three and a wife. So I have a lot going on, but this is really my passion. So I really want to share with you guys a little bit about estate planning and business planning for small business owners. So that's what we're going to talk about today. And I'm going to go ahead and share my screen, and hopefully you can all hear me okay and see me. So can everybody see my screen?
Yes.
Okay, perfect. So I'm going to jump right in. This is going to be a pretty lengthy hypothetical based presentation, but it's also going to be an interactive one. I'm going to ask you guys some questions throughout the presentation, and I don't mean to call on anybody, but I just want to get a good sense of what people know about this topic. And okay. And just a reminder that the best way to learn is to kind of pay attention. And I hope that you find it useful because you do deserve this knowledge really for your business and for your family. And then at the end of the presentation, I'm also going to open it up to questions and stop sharing my screen. So any questions you have about estate planning, business planning, I'm happy to answer any of them. So before we begin, just to get a little bit of a sense of the people that joined this lab today, just want to find out, if you don't mind sharing, if any of you have an estate plan or a business succession plan in place. And you can just raise your hand, you don't have to volunteer. Okay. Oh, not that many.
That's why I'm on this call.
I know. Well, I will be one of the people who has both. So, okay. And then if you don't have an estate plan in place or a business succession plan, if you don't mind sharing and telling me why, like, why do you think you've never gotten around to planning your estate?
So you can just come off mute and speak it or drop it into the chat, whatever's easiest for you.
Too busy, too old, didn't know where to start.
Too old? That's a good one. Usually too young.
I put a message in the chat a second ago. I did a will/estate plan, such as that is, since there's no estate, but years ago when my kid was born, but it hasn't been updated since, and she's turning 21, and I have never done any kind of business succession planning because up until now, my business has been just me. And I thought, well, when I'm not doing it, it's done. Right up until one of our recent labs where I was finding out maybe it doesn't have to be done. Maybe I could, sell it, in which case, in that eventuality, this will be awesome information to have. So thank you.
Well, great. Thank you so much for sharing that. Yeah, so as business owners, we don't normally realize that, especially if you're the primary breadwinner, if your family relies on your business a lot, and if that's your major asset, and if you're gone and you can't continue the business, then your family's kind of left with no income. That's the very real consideration that a lot of my clients that are business owners typically have, because once the person who's in charge of the business is gone or incapacitated, then that's where the family just kind of the influx of income kind of stops at that point. So we're going to talk about that today. So thank you for sharing. Oops, I need to go back. So everything that you shared and just hearing from my clients about why they don't have an estate plan in place kind of touches on what we're going to learn about here today. So things happen. We all know that. They just do. And you didn't come here to learn that from me. We all know that something's going to happen to all of us someday. So the real question is, what happens next? And by exploring what happens next, today you will learn about why estate planning should matter to you, even and actually, especially if you don't have a lot of money in the bank left for your family. And then also we're going to learn about how handling your estate planning is actually going to support the growth of your business and what your next steps should be if you want to be sure that your family and your business will be well taken care of in case anything happens to you. So today we'll really be thinking about what happens to your business, to your loved ones, and all of your assets if you become incapacitated or die. So we're going to touch on things like, would your team be able to run your business without you? Would your income continue? Would everything just come to a screeching halt, leaving your family at risk? Would your family have to be stuck in court and conflict for years? And would your family even know what to do and who to turn to and how to start the process? And if you have kids, or especially minor kids like I do, we're going to talk about what's going to happen to them. And so we're going to explore those questions by looking at what's going to happen and how loved ones can cope with the unexpected from two different perspectives. So the first perspective is going to be our before perspective. We're going to focus about what happens if you have no estate plan at all, or maybe just a document from 20 years ago. And then the sad day comes and you don't know what's going to happen. What you're going to find out is that your family and your business are going to be left vulnerable. What will they have to go through? So for each sad day that we're going to go through today, we're going to start out with the before perspective first. And the way to think about it is, what's going to happen if the state were to make the decisions for you? So not your decisions, but the state of Colorado was going to make decisions for you. And you're going to learn that what the state decides is probably not what you would decide if it was up to you. And then the after perspective is we're going to learn about how a potentially tragic scenario can be turned into the best possible scenario for you and your loved ones, keeping your family out of court and out of conflict. And all of that comes down to a clear estate plan or a business succession plan and clear communication with your loved ones. And then also we're going to learn how to start the estate planning process, how long it usually takes, and then how much it costs. And also, I'm going to be sharing some of the information about the firm as well. So before I dive into all of that, I want to give you a little bit of a background about who I am and why I dedicate myself to doing estate planning and business succession planning for many, many families that I've worked with. And so my story as an estate planning attorney really comes from having a business, having been a business attorney for a big law firm when I just graduated from law school, and also becoming a new parent. So I have 3 little ones right now. So when I just had my first one, I realized that this was like a big change, a big turning point. And at that time, both my husband and I just had simple wills, just because I'm an attorney and I used to practice business law. And I just thought that having simple wills is enough for us. So it was basically like, if something happens to us, then my parents become our chosen legal guardians, and everything goes to the kids. So that was what we had. So we have 3 little ones now. We have 2 businesses. So my husband's a dentist and he has his own dental practice. I have my law firm. We also have life insurance, investment accounts, some rental properties, bank accounts, a lot of stuff, IRAs, that a typical family usually has. So a lot of moving pieces. So, and really my turning point was when my husband and we just had the 2 boys at the time. That was a few years ago. We decided to just get away for the weekend. And we hopped on a plane to go to Paris because there was a direct flight being offered at the time. So we left our kids with my mother-in-law at home, and we just jumped on the plane to go to Paris for 3 days. And I can never sleep on planes, even though I'm pretty sleep deprived ever since I had my kids. But I just started thinking, what if the plane were to crash and we never made it home? Like, on the most practical level, what would happen to my kids and all of our assets with just having a simple will at home that nobody even knew where it was? And what kind of unraveled in my mind was just so horrific to me that when we got home, I talked to my husband about it, and we decided to put together an estate plan that really covered all of that. But if we think about it, who would even know how to gather all of our accounts? Who would have access to everything that we own? Nowadays, everybody that comes to see me, and myself included, we all have everything that's in our phone. It's touch screen. I mean, like touch ID, face ID. You can never access your paper statements. Some people don't even have paper statements anymore. I get clients who come to me and they don't know what each other owns, what kind of an old 401k you used to have at some firm 30 years ago. There's just a lot of moving pieces. So unless your executor has an inventory of all of your assets with account numbers, it's going to take them years just to collect all of that. And that's a big part of why we have about $600 million sitting in the Colorado Department of Unclaimed Property. And the major reason for the money going there is because somebody dies and then the family overlooks like a life insurance policy or an old IRA or some other type of an investment account that nobody knew how to access. And that, after it sits dormant for about 3 years, it just escheats to the state. So that's how a lot of assets get lost. And then when you have minor kids, also just appointing a guardian who lives out of state is not a great idea because your kids could end up in child protective services. So, and then the business, if my husband and I were gone, who would know how to deal with our employees, how to pay our leases, how to pay all of the bills associated with the businesses, how to liquidate? I just quickly realized that my simple will left so many questions unanswered. And on the practical level, the person stepping into it would know nothing. They wouldn't have any idea on what to do, even if they read the will and hired an attorney. So that was my turning point, and that's the plan that I'm going to share with you guys today. All the pieces of that plan to make sure that your family's covered and your business is included in your estate plan. So now that I've shared a little bit about myself, I want you guys to kind of have a mental picture in mind of who is it who needs your protection. So for me, it's obviously my kids. If I'm no longer there for me, they need the easiest transition possible. And for all of you, you probably have some people like that too, some people or charities or maybe organizations that you want to protect. So I kind of want you to have that mental picture in mind as we're going through the presentation today. So now we're going to jump into learning about estate planning and business succession planning by getting to know the Bliss family very well. So the Bliss family is going to have to experience 5 very sad days today for us to be able to learn about these important topics. If you have questions as I go, you can either interrupt me or just write them down and then I'll answer them when we open it up to Q&A at the end. So with that, let's meet the Bliss family. So this is a beautiful family. We have Mark, Molly, Alexander, Benjamin, and Caroline. Mark and Molly are happily married. They own their lovely home here in Colorado, and they have 2 wonderful children, Benjamin, who is 12, and Caroline, who is 10. And then Molly was also married before, and from a previous marriage, she has a son who's 15 years old, and his name is Alexander. So Mark and Molly have joint checking accounts. They're putting away money for retirement. They both have life insurance, and also they came into the marriage with a little bit of savings already. They each have a solely owned investment account, and Molly also has a business account. And in Molly's solo accounts, she also has inheritance that she got from her parents when they passed away. So, and then as I mentioned, Molly was married prior to marrying Mark. As the result of the divorce, she got sole ownership of a vacation home in Lake Tahoe. And now the Bliss family owns the home and they go and visit it once or twice a year and they really enjoy it. And so Molly is the primary breadwinner in the family. She set up her own accounting firm prior to marrying Mark. She has been very successful. She's been running it for 10 years now. She has 4 employees. She leases her office space. The business is structured as an LLC, which is a Colorado limited liability company. The business is solely in her name. She has 2 business accounts for the business, a business checking account, a business savings account. Mark, as the spouse, is really not involved in the business. He has a part-time job and he just loves spending the time with the kids. He never really goes into Molly's accounting firm because she's so busy all the time. So he doesn't really know what's going on with the business. So it's really your everyday kind of family that you can imagine. But this poor family is going to be put through an absolute train wreck. So I hope you bear with me today. And as a side note, I hope you bear with me because I approach these topics of life and death. I don't take myself too seriously when I talk about it, and I enjoy some humor. So please don't get offended. And it's really important for us to learn about these things. So that's why the hypothetical are going to be pretty brutal, but it's just for the purposes of education. It's not based on real events, but we just have to learn about these things. So with that, let's jump into sad day number 1. It's a ski weekend and the whole Bliss family is having a great time skiing up in Breckenridge. And they brought all of the kids and their friend Dina with them. Dina is a longtime friend of the family. She doesn't have any kids of her own, but she loves Caroline, Benjamin, and Alexander just like they were her own kids. It starts as a really fun 3-day weekend on the mountain, beautiful weather to start with, but unfortunately, a fog descended on the mountain pretty quickly, and Mark and Molly, who were all going downhill very, very fast, totally lose sight of each other and they collide into each other. And before we know it, we have a skiing gone bad scenario. There's skis and poles everywhere. And where are the kids? Mark and Molly are parents of minor kids. So what happens in an emergency situation with minor children whose parents are dead or missing? So ski patrol tends to Mark and Molly and they find a beautiful picture of the Bliss family in Mark's wallet. So now they go to the ski school and they need to find the kids. They put Mark and Molly on a flight for life to a hospital to Denver. And now they also call Molly's sister Mindy in Texas, who hops on the plane to get to Denver. So the question is, who's going to stay with the kids while Mark and Molly are at the hospital and Molly's sister is in Texas? Any guesses? Could it be the friend Dina who they brought with them?
Hopefully.
So it turns out that Dina is actually disqualified. Only adult blood relatives can be the default temporary guardians when minor children are involved. So Dina is disqualified. She's just a friend. This is obviously a huge problem because we don't have anybody else in the state who can come and take the kids. So now what's going to happen is that the police are going to call Child Protective Services. If Mark and Molly could communicate, they would say, please let our kids stay with Dina. We know and trust her. But unfortunately, they cannot communicate. And so now we're stuck in this no man's land, not knowing who the kids are going to end up with until some blood relative shows up from out of state. So if you're a parent of minor kids like I am, for me, this is the scariest part. If something happens to me and there's nobody in state who can take my kids right away, they're going to be taken into CPS, and that's just very stressful for the kids. And I've seen it happen in my practice, and you don't ever want to add that on top of the grieving for little kids who don't know what's going on. So obviously this is a nightmare scenario. So let's do something better for the Bliss family. So Mark and Molly put a short-term guardianship emergency plan in place to name Dina as a short-term guardian for their kids. So when we talk about guardianship, it's not only about long-term guardians as to who's going to raise my kids if I'm no longer there. We also need to have short-term guardianship nominations for cases like this. If there's an emergency scenario, it has to be a local person who has the guardianship nomination that they can just pull up on their phone. And that way the police is not going to call CPS and the kids can just peacefully go and stay with that person. But it's not going to work unless you share copies with that guardian. So sharing copies is very important too. All right, so with that, let's jump into sad day number 2. Molly's injuries linger. Unfortunately, Mark recovers, but Molly is still unconscious and suffering from her injuries. Mark is making Molly's medical decisions for now, despite the emotional burden of the whole experience. And Mindy just landed, and she immediately gets on the phone to the hospital. She wants to know what's going on with her sister, but she hits a big red stop sign called HIPAA. The doctors can't talk to anyone about Molly's medical condition without Molly giving explicit permission in writing. So Mindy's frazzled, she's upset, she's yelling at the doctor. But the doctor says, I'm sorry, there is a medical privacy law called HIPAA that says I can't talk to anyone about your medical situation. So Mindy slams the phone down in complete frustration. So now Mark has been making medical decisions for Molly before Mindy arrived, but now that Mindy is there, they legally get to make medical decisions together. So you may be thinking, but why? Mark is married to Molly. He should have the exclusive right to make her decisions. But here's the big surprise. No, he doesn't. The law doesn't presume that your spouse has your best interest at heart. The law just says that any interested person or persons, plural, can make medical decisions for somebody who's incapacitated when there's no estate plan in place. So this means that Mindy and Mark are on equal playing field when it comes to Molly's medical decisions, and they can have completely opposite opinions about what should happen. So you may think that this is crazy, and Mark sure does. He's married to Molly, he just thinks that it's his decision. And to the extent that there's an impasse, the doctors are just going to tell the parties, listen, it's not really our call to decide who to listen to. So why don't you go to court and duke it out in front of the probate judge? So that's what Mark and Mindy will have to do. But before we go to court, Mark is also trying to keep up with all of the medical bills as they're piling up. And also Molly's firm, there's payroll that's due, there's a lease payment that's due. So Mark wants to go to the bank and access Molly's accounts so he can run her payroll, pay all of her business bills, and also pay for the medical bills. But remember, Molly has a savings account that's in the name of her business and also in the name of her sole investment account, where she put the money that she inherited from her parents. So Mark shows up at the bank and he says, I'm the husband. And the banker tells him, I'm sorry, but you can't access the account. And Mark says, I'm sorry, but we're married. The banker says, same as with the medical decision, it doesn't matter. The banker tells Mark that he can't access any of Molly's accounts and handle Molly's business and pay her payroll or do anything until he goes to probate court and gets appointed as the executor, which can take months or years. So not to mention that Mark is dealing with a lot here. He has 3 kids, he has an incapacitated wife. He doesn't want to have to go to court. He has no idea what to do. The employees keep calling him and asking him when Molly's going to be back and how they should approach dealing with the clients and the payroll. But unfortunately, Mark is just so frazzled at this point, he really doesn't know what to do. So now he has to go to court, and this may sound crazy, but he has to go to court to both prove that he can make Molly's medical decisions for her and that he can also be the responsible individual who's going to make her financial decisions for her. When it comes to the finances, Mindy's thinking, well, this is my sister's money and she inherited some money from our parents, so I really don't want Mark managing this money, so I'm going to petition the court as well. So my question to you is, who is the judge going to choose, Mark or Mindy? They're both pretty interested in handling her affairs. So I'll give you the answer. And as with everything, when it comes to the court of law, the answer is we don't know. The judge is the third party who's going to collect a bunch of background checks from both Mark and Mindy to determine who is the responsible adult who can handle both the finances and the medical decisions. So Mark thinks that this is crazy. This is such a big hassle. He really doesn't want to be in court fighting with Molly's sister, but unfortunately, that's what they have to do when there's no estate plan in place. So this is obviously not an ideal scenario. So how can we fix this for the Bliss family? So with Molly's medical power of attorney, Mark is solely making Molly's medical decisions, even if Mindy is there in person. Now, Mindy can be very opinionated and she can be as loud as she wants, but at the end of the day, legally, Mark can show the medical power of attorney to the doctors and they will listen to him and him only. And under Molly's HIPAA release, Mindy can call the doctors and find out what's going on. Mindy is named on the HIPAA release, even though she's not Molly's medical power of attorney. All the HIPAA release means is open communication. And most importantly, Molly gave a copy of this HIPAA release to Mindy so she can just learn about her medical condition from the doctors. And with the financial power of attorney that Molly signed as part of her estate plan, she names Mark as the sole decision maker when it comes to her finances. That means that when Mark walks into that bank, he can bring the financial power of attorney with him and access any account of Molly's without having to go to court. So this is a huge time saver and also a money saver, because instead of having to go to court, now Mark can just bring those two documents to the doctors and to the bank without having to go to court. So this is saving him a lot of hassle, a lot of stress, a lot of time, and a lot of money as well. So here's your lesson number one. The only person other than you who can make your decisions is the probate judge. It's not your husband, it's not your wife, it's not your partner, it's not your mom, it's not your kids, it's the judge. So don't let that happen. Take control now. So now we have arrived at sad day number 3. Unfortunately, the doctors delivered bad news to the family. Molly is, in their judgment, completely, irreversibly, and terminally ill. So now what happens? Who makes the call as to when to remove her from life support? That would be whoever the probate judge selected as her medical decision maker. And whoever that is making a guess as to how long Molly would want to hang on. So can you imagine? Nobody wants to be in this situation. Not Molly and not any of her loved ones. And I see this happening in my practice, unfortunately, when the family has totally different views, or they have no idea whether their loved one would want to hang on for no days, 7 days, 30 days, or indefinitely. So maybe Mark is thinking, there's no hope, and I know my wife wouldn't have wanted to be this way. But maybe Mindy is thinking, I know a miracle would happen, and I believe in God, and I have a deep religious feeling that Molly would recover. So after a lot of tears, accusations, when to remove somebody from life support is decided as a group. And now Molly is removed from life support and she passes away. And now with Molly gone, we have a big issue with her business. She is the sole owner of the business. She is the only main licensed professional in the business, and the business needs to be dealt with. She has no successor in place who can step in and take over the actual bread of the business, which is the accounting. So no one is there to take over. She has a couple of employees. Will Mark need to hire another professional accountant to run the firm? Who will train them? Mark thinks this is too much. To be honest, Mark is so devastated by the loss of his wife that this is the last thing on his mind. He wants some space for his grieving, so he doesn't return the calls from the employees or from any of Molly's clients, and he kind of puts it on the back burner for now. He's focused on the funeral arrangements, dealing with the kids, dealing with the family. He has a lot on his plate, and the employees just leave him some space for now. A few weeks go by, and then the employees don't really know what to do. They keep getting calls from the clients, from the landlord, from all of the business creditors, and all they can do is just record a voicemail that says that Molly has passed away and they're unsure of what's going to happen next. This causes the business to lose a good number of their clients. And out of the 4 employees, 3 decide to leave because they can't wait for Mark to pay them and they just don't know what's going to happen. As the clients keep leaving, the firm is not generating any income. There's some money in the business account, but there's no influx of profit. The lease, the utilities, the payroll, operating expenses, everything, bank loan payments are still due. The bills just sit there and accruing late fees and interest. So finally, after the funeral is over and Mark regains some composure, he comes to the office and talks to the one remaining employee. He finds everything in a complete mess. He doesn't know what to do, how to deal with it. So he decides to sell the business while he still can. So what he does is that he calls the business broker and explains the situation. The business broker understands and he says, I'll do my best to put the business up for sale as soon as I can. He just needs some information on the business financials to determine how much to list the business for. But who has the financial information? Mark doesn't because he's not really involved in the business. The remaining employee doesn't either. The CPA has all of the business information, but when they call the CPA says, I'm sorry, but I need a power of attorney or an appointment of the executor to be able to disclose this information to you. So now Mark is not sure what to do. So remember the probate court that we had to go through? Here's the place that Mark has to go back to determine how to handle Molly's estate, including her business. In the absence of a will, state law decides who inherits Molly's estate. And Mark wants to be appointed as executor so he can deal with the business and all of the distributions. Mark is obviously very confused about this whole process and about all of the paperwork. So he goes and hires a probate attorney at the rate of $300 an hour to help him in the process. As part of the process, Mark has to be bonded and he has to submit to a background check, which he finds pretty intrusive, but he has no choice at this point. The court needs to know that he's reliable. He also realizes that he needs to issue creditor notices and they're going to run in the local newspaper for at least 6 months. And during this time, he has no access to the estate. And he can be personally liable to those creditors if he starts accessing Molly's funds before all of the creditors take their priority. So Mark finally gets appointed as the executor and gets the business listed for sale after about 6 months of delay. So now we're really on the court's timeline. We don't know how long this probate process is going to take. We don't know how much it's going to end up costing Mark with the attorney at the rate of $300 an hour. How much will the business be sold for? How much will Mark be able to recover and how much will the kids be able to inherit? Will the kids just inherit everything when they turn 18? Will the employees go with the business? And lastly, and most importantly, what would have Molly wanted? What would be her plan? Without a plan, we're kind of left in this no man's land, not really knowing how and when anything's going to happen. And then also remember the vacation home in Lake Tahoe. Mark is about to find out that this vacation home is not paradise anymore, but a complete nightmare. The vacation home was solely owned by Molly. So when you call the county clerk in Lake Tahoe and find out who owns the house, they're going to say Molly. That's because her name is going to remain on title until somebody is legally entitled to transfer ownership into her heirs' names. And nobody's entitled to do so unless they go through probate. But here's the surprise. Every state has its own probate system. And if you have real estate in a different state, that real estate is subject to the probate law of that state. So this means double probate for Mark. He's going to start the process here in Colorado. We're going to get him up to a certain point, and then we're going to send him down to Nevada. And I can't help him there because I'm not licensed in Nevada. So he needs to hire another attorney at the rate of $300 an hour just to put that one property through probate in Nevada. So he's going to have to be dealing with double probate just because of this one vacation home that's out of state. So this is clearly a nightmare scenario. So let's do something better for the Bliss family. So first, let's look at the idea number one. Molly signs a simple will that says, I leave everything to Mark. If Mark dies, I leave everything to my kids. So everyone has probably heard that you need a will. So this sounds like this could be a good plan, but there's a hole in this plan that I think will surprise you. So what Molly didn't know is that at the end of the day, your will does not control all of your assets. Joint ownership and beneficiary designations actually override your will. So let's talk about these three buckets. So first, when somebody dies and their heirs call my office, the first thing I want to know is not whether they had a will. I first want to know if they owned anything jointly and whether that joint owner is still living, because it doesn't really matter what your will says. If you have somebody listed as a joint owner on your house or your bank account or anything else, that surviving joint owner is going to get that asset no matter what the will says. So if we bring it back to Molly, if Mark remarries and then he puts his new wife on the name of the house that he owned jointly with Molly, even if both of their wills say we want everything to go to our kids, the new wife is going to get the house, not the kids. So here you can see how joint ownership will actually override your will. And then the next question I typically ask is, what does the beneficiary designation say? So all of us have beneficiary designated accounts. Those would be IRAs, life insurance, 529 accounts, anything that asks you to designate the beneficiary. So that also overrides your will. So if Molly had life insurance and the beneficiary of the life insurance was still her ex-husband, no matter what her will says, that ex-husband's going to get that life insurance check when Molly dies. So then if assets are not jointly owned, or if there's no beneficiary designation, everything left over is your probate estate. And sometimes people leave nothing in their probate estate. So this is because joint ownership and beneficiary designations actually override your will. So now the probate estate goes according to your will. If you have one, if you don't have one, it goes according to the Colorado laws of intestacy. And a big surprise for people, for some reason, there's a big confusion here. A will does not avoid probate court. So a will is actually your ticket to probate. Everything, including the homes, everything that you own, will go through probate if you have a will in place. And if somebody leaves no will, they still end up in probate. Probate court is pretty lengthy. There's big delays because of COVID. And also it's a public process. So anybody can go online and look up your case and pull up your will and see how much your kids are getting. So for some reason, when I work with families, they just assume that having a will somehow solves all of your estate planning needs, but it definitely doesn't. And so I'm going to share with you some other techniques here today. So here's your idea number two. Molly gets the trust instead. And in the trust, she basically says the same thing. I leave everything to my husband, Mark. If he dies, I leave everything to my kids. So how does it work that it basically says the same thing, but it's avoiding court? So let's first talk about what is a trust. So a trust that I'm talking about is a revocable living trust, and it works as the will substitute. So there's all sorts of types of trust out there, but we're talking about a revocable living trust. That is your vehicle to avoid probate. So it works as a will substitute, and here are the three buckets in the context of a trust. So first, we're still going to look at the jointly owned assets, and we're going to change the name from your joint owners into the name of your trust. Then we're going to look at the beneficiary designations, and we're going to change those beneficiary designations to list your trust as the beneficiary. And third, we're going to take all of your other assets and also change them into the name of the trust. So there's no probate estate anymore. Everything you own is now owned by a trust, which is a separate legal entity. And that's why none of your assets have to go to probate court. So there's no court or delay required. All assets are immediately available to your loved ones without any court fees or delays. So think of a trust and funding it as the toys in this little wagon. So when you were a kid, you probably loved putting all of your toys in the wagon and just pulling it around. I know my kids love doing that. So the probate court is only avoided for the things that you put inside of your trust. So this is what we call trust funding. So let's look at this scenario. You got a trust, you got the wagon, but you never updated your account ownership titles, your house, your IRAs, anything. So now you have a trust, but it's an empty vehicle. All of your assets are outside of the trust. So I see this happening a lot with people doing their own estate planning or going to an attorney who's just going to write a template for them and then hand it to them and not explain to them how the funding process works. So this is actually not avoiding probate. This is not avoiding anything. You just paid a lot of money for a piece of paper, but you never funded it. So this is not actually avoiding probate. This is inviting it. So now we can see that all of the toys are inside the wagon. So bring it back to Molly. She had her business and her separate bank account. When Molly sat down with my firm, we went through a possible scenario of taking everything through probate, and Molly decided that she didn't want to do it. So what we did is we created her living trust, and then we took her assets one by one, including her business and the business accounts, and we put them in the trust one by one. So now when she passes away, Mark is the successor trustee. He just steps up and he can do everything with the accounts, with the business, with everything inside the trust according to the trust agreements. So no probate court was necessary to make any of this happen. No court, no conflict, and no delay. And then also the vacation home can also be put in the trust to avoid double probate. So how does this work? So when Mark and Molly decide to do their trust and they create the Bliss Family Trust before anything happens to them, they talk to me and I collect their inventory of all of the assets that they own. And they tell me that they own this house out of state, which I have a lot of clients who do own properties across the United States. So what we do is we just record the deed from their individual names or their names as joint tenants into the name of their trust. So now we're avoiding probate potentially in 2 or more states just by putting this house inside of the trust. So you can see how this is saving them a ton of money and a ton of time. So here's your lesson number 2. A review of all of your assets, including your business and any out-of-state property, should be part of your estate planning conversation. A document alone is not going to protect you because nobody will know what's even subject to your estate plan. So as far as the medical directives, Molly ahead of time in her estate plan can decide her final moments. She can say how long she wants to remain on life support and have a living will that says, I want to be left on life support for 7 days, and then you remove me. So this saves a lot of argument, a lot of tears and stress to her family. So here's your lesson number 3. If you want control of your loved ones and your assets, you must act before it's too late. When something happens, it's a done deal. And what the law says is what it says. And your family is kind of stuck with what you did or didn't do. So the good time to do your estate planning is now, because we never know when something's going to happen. So finally, let's just talk about our sad day number 4. Many years later, Mark ages, and now he's old and gray. He never remarried, and now he doesn't know if he needs long-term care or if he needs to qualify for Medicaid. When he tries to qualify, he realizes that he may lose all of his assets. He needs to spend down all of his money just to qualify for Medicaid. And so he never planned for it. And now he passes away, and he never got an estate plan. So now we have a call from his adult kids who are all in their 30s now. So whatever is left of Mark's estate goes to his adult kids outright and unprotected without any restrictions. So what are they going to do with it? even if they're technically adults who are responsible and immature, they may be still a little irresponsible, or they can be subject to some future creditor claims or divorces. So maybe they're influenced by somebody who wants them to invest into some shady business deal. So outright distributions, either through a will or a trust, are never a good idea, because I see inheritances being lost in a matter of a couple of years for something that you have worked so hard to build. So no one is there to help your kids decide how to handle this money. So all of this can be gone in a matter of months. So we never know what they're going to do with it. So how can we fix this? So first of all, you can plan ahead. If you're thinking about needing long-term care or qualifying for Medicaid, we have to start planning now, because Medicaid has a 60-month look-back period. So if you have any aging parents who are thinking about long-term care or qualifying for Medicaid, they need to plan in advance. Also, for everything left over, you can build in the time for your adult children to adjust, and you can give them a financial mentor to help them with this major life change. Even if they're responsible, mature adults, you kind of want to be able to encourage them to spend the money in the right way. The nice thing is that if you leave the money in a lifetime asset protection trust, that money is never subject to any future divorces, creditors, lawsuits, even bankruptcy. So your children are always going to have this trust fund available to them, no matter what sticky issues they may be going through in their lifetimes. So here's your lesson number 5. The IRS always comes first. The state tax exemption is really high right now. That's why I don't really mention it. It's at $11.58 million now. So if you're lucky to be over that number, 40% of everything over that is going to go to the IRS, but we can plan for that. We can avoid an estate tax too. But more importantly, your loved ones need time to adjust. So build that into the trust for them. It's a really good idea, so they can have ongoing guidance as they go through life without you. So now that we've gotten through all of our lessons, I just want you to remember why you're here and why you're learning about this. So for me, it's obviously my kids. I know this is not the most exciting of topics, but as business owners, as parents, we have to consider these things. Otherwise, we're going to leave a mess behind. And my saying is always, leave a conscious legacy. Don't just leave a mess behind and think that your kids are just going to pick it up and somehow decide what to do with it. So be conscious about the choices that you're making for yourself and for your loved ones. So now I just want to tell you briefly about how our firm is different and what kind of services we offer and how the process works. So the traditional estate planning experience, unfortunately, I see it a lot, is that you just get a template will or trust. Nobody ever guides you to the trust funding. Nobody ever updates your will or trust. It just sits there on your shelf, getting dusty. And then when the time comes, your family is going to go to court and they don't even know who to go to or who to contact. What we do is it's all flat fee, agreed to in advance. We're planning ahead to avoid problems, and we're relationship based. So what that means is that we give all of our clients complimentary lifetime memberships with the firm, with complimentary 3-year reviews for all of your estate plans. So if you create a trust today, and then 3 years from now, you need to update something, we're going to be there for you. You're never going to have to go to another firm and pay to redo it all over again. And such things as powers of attorney, they go out of date, so you need to update them at least every 6 years or so. So here's our promise to you. Your estate plan is going to leave no stone unturned and will give you peace of mind that your loved ones are kept out of court and out of conflict. So I actually love the interaction with my clients, and I know that things are going to change. There has never been an estate plan where the person just signs it and then they die the next day. Things are going to change. And so the relationship is really what's very important in estate planning, to be able to have that legal guidance as your assets change, as your family dynamics change, as your kids are growing up and you start having grandkids and you want to provide for them. So changing that to kind of accommodate your changing lifestyle is key. So here's the 3-meeting process that we typically have at the farm. We start everything out by having a family wealth planning session, which is a 2-hour working session with an attorney, where we sit down and we review all of your assets and all of your needs and your family dynamics and everything, all of your objectives. And we spend about 2 hours with you creating a custom tailored plan for you. And you can pick your own fee during that time. The fees range anywhere from $1,500 to $8,000, depending on the complexity. Most of my clients are somewhere in the middle of that. We disclose all of that upfront and in advance, and that fee also buys you the lifetime membership with the firm. Then after the family wealth planning session, we have you back for your signing meeting where you sign all of your documents, and that's where your plan is legally in place and you can celebrate. And then in about 2 weeks from then, you come back again and we have your final meeting when we deliver your binder, your electronic documents, everything on the USB drive to you, and we set you up on our 3-year reminders for those complimentary meetings. So I actually view the final meeting as the start of our relationship. We're going to be your legal guide for throughout your lifetime, basically, and that's what I really value in the relationship. So, and really at the end of the day, it's about what you're creating. You're creating a personalized plan, capturing your family wealth that's going to give your loved ones and yourself peace of mind. So, as a bonus for everybody that comes through one of my webinars or one of our Wine and Wills events, or I know Sharon's going to record this and share it on the NIA website, we typically charge $750 for the family wealth planning session. But for everybody who watches the video and comes pre-educated, so they know the importance of estate planning, so it makes my job a lot easier. When people come after watching one of my presentations, we waive that fee because that meeting usually runs a lot more smoothly if you come pre-educated. So for everybody watching the video today or online when it gets posted, you can save the $750 off the family wealth planning session and have that planning session absolutely free. And we're also going to give anybody $250 off of any of the estate plan, plus some financing options, because the time to do this is really now. There's no excuse to wait. And so that's why we want to make it as easy as we can. So that's the bonus for everybody bearing with me. And then here are some of my raving reviews. And if you have any questions, you can also email us at the email address that you have. The last slide has the scheduling link that you can book the family wealth planning session. We offer them in person or via Zoom. So if you can, if you're interested, or if you feel like you know anybody who's interested in having this meeting with an attorney to talk about their estate planning needs, feel free to follow that link and schedule something. I can also post it in the comments if you want. So thank you so much. I feel like I've been talking a lot. I hope you didn't get bored. I'm gonna stop sharing my screen and open it up to questions or comments or wake some of you up. I don't know how to, oh, okay, stop sharing.
There we go.
Okay.
Perfect.
Thank you guys. I hope you found it useful.
That was
Yeah.
awesome. And I
That
bet
was
you
great.
guys have some questions. So this is a great opportunity with an attorney at your disposal to get some clarity. So you can hop off mute and just ask your questions.
So I have a question actually, and this is pertaining to something that just happened. So doesn't Colorado have a small probate rule of
Yes,
if it's under 64,000 in the estate that they don't have to go through probate?
Yeah, it's under 70,000 in 2020. So
I'm
if you
sorry,
have,
you cut out there for a second on me. I'm sorry.
oh yeah, the smallest state exemption is 70,000. in 2020. So
Okay.
if you have anything, if somebody died and they owned less than 70,000, they don't have to go through formal probate. All you have to do is file an affidavit of small estate, and that's it. But for everybody owning real estate, that just puts you out of that exemption right away.
So, because I have someone who the mortgage on the house is like 268,000, but the worth of the house is probably 340. But that wouldn't even matter. That automatically would put them into.
Yeah, it's not the equity in the house, it's the fair market value. So the house is going to have to go through probate,
Okay.
unfortunately.
Sorry, that's what I thought. There were some heated discussions on whether or not that was true, and I was like, well, you're all wrong, but this was a perfect opportunity, so thank you.
Sure. And if you need any help with filing for probate, let me know. I can help with that too.
Yeah, definitely. Typical unfortunate situation, recently divorced, all adult kids, living with one of the adult kids, and passed away of a heart attack. So,
yeah, I know. Unfortunately, I hear sad stories every single day in my career. So I know things happen. So yeah, I'm actually going to type in my email address in here so that if you have any more questions or anything like that, you can just email me and I'll be happy to help.
great, thank you.
Other questions? That doesn't mean you can't ask questions right now.
Yeah.
I have a question. In your story about Molly and Mark, or whoever the wife was, Molly, right?
Mm-hmm.
And him not knowing anything about the business. Doing all that stuff you talked about really didn't help him know any more about the business. So what would you have told Molly and Mark to do earlier that they didn't do besides, the living trust and all that?
So there's kind of two ways you can go when you have a business. You can either just incorporate it into your estate plan and have it assigned to the trust so that your spouse doesn't have to go through probate. They can just immediately list it for sale or liquidate it. And that way they don't really have to learn anything about the business. They can just step in and be sort of the business owner right away, and then they can just liquidate it. The other way is that you can actually name a successor. You can find, like, I have a successor for my business. I don't want to liquidate. I want another attorney to take over. So does my husband. And his hope is actually that one of our kids is going to grow up and be a dentist so they can take over. But for now, he has another backup dentist who's going to take over. So the trustee, like if I die and my husband's my trustee and then I have a named successor, then my husband's going to be working with the successor to make sure that the business is running smoothly. So they're both going to be able to get access to all of the business financials, accounting, all of that without having to go to court. They can just work smoothly together to kind of keep the business going. Or they can later decide they want to liquidate and sell it, which is also in the authority granted to them by the trust agreement.
So Molly would have had to pick another accountant ahead of time to do that she trusted.
And train them hopefully to.
Yeah. So if she didn't do that, then putting it in the living trust was her other option, right?
Yeah.
Okay.
Then just save the value of it while probate's going through and they keep losing equity in the business.
Yeah. Yeah. Okay. Thank you.
Mm-hmm. Any other questions?
Yeah, so I guess my question is, so if someone were to pass away, who is the first person that a child or someone in the trust, do they contact the lawyer first, or what do they do first should something happen?
Yes, if they're working with my firm, then they would call me. If they're working with somebody who wrote their will 30 years ago, they probably won't find that person. Or sometimes they would just call any estate planning attorney and just retain them right away to help them with probate.
Okay. That's a two-pronged question because I'm the executor of my aunt's estate, and she's in Tiburon, California. So I was just trying to figure out, she's 89. So I just want to make sure we think we've got everything wrapped up in the trust. I just need to know, just kind of personally what I need to do should she pass, and who do I contact first?
So if she has a trust, then you're not the executor, you're the trustee. So that means if she has a trust and it's properly funded, meaning that none of her assets are outside of the trust, then as the successor trustee, you will just get the trust agreement,
Yes.
read it, and understand what to do with it. And if you don't, then you can hire an attorney or a CPA to help you to guide you how to administer a trust. But usually administering a trust is a lot easier than taking something through probate, because you can just read the trust. The trustee has all the powers that you can possibly imagine. So you can go and access all of the accounts, all of the real estate right away, and just administer it according to the terms of the trust.
Okay. That's good. I'll go back and then read the trust that we've got then. Thank you very
just
much.
make sure that that all of her assets are inside the trust, and make sure there's like an inventory of everything that's in the trust, so you don't have to go around looking, because I see that happening a lot when people have the trust and they think it's funded, but then they don't really know what it's funded with, because it doesn't say it in the trust what's in it. An inventory of assets has to be separate so that you know exactly what kind of accounts you can access as the trustee, and not have to look for statements or deeds or anything like that.
Okay, cool. Thank you.
Okay, so I have a couple of questions. So one, if you have the living trust and you put your house in that trust, what happens if you are still living and decide to sell your house?
Oh, that's a great question. So nothing happens. You can just sell your house, because the trust is, the living trust is your alter ego. So it's still tied to your social. There's no separate tax return. It only becomes irrevocable with its separate tax ID when you die. So while you're living, you can revoke it. You can move accounts. You can just, you are your own trustee basically when you live. So you can just let the company know that I'm selling my house that's in the name of the trust. So the deed's going to be signed by you as the trustee of your own trust. And that's going to be the same for all of the assets that you have.
Okay, so when you move the deed of your house into the trust, is that like a legal paperwork thing?
Yeah.
How does that happen?
Help you do it. We actually
Okay.
would just do a warranty deed. So I would ask for the original deed of the house when you took title to it, when you bought it. And then we take the legal description and everything, and we draft a new warranty deed for the house. And we record it with the county along with the statement of authority saying that your trust is legally exists in Colorado. And that way, when you look up your property on the county assessor's website, it's not in your name, it's in the name of your trust. But you are still your trustee, so you can do whatever you want with that property while you're living.
And so then once you cease to be living, is it possible or impossible or just not advisable to have two people listed as co-trustees?
That would really depend. Some of my clients list their kids as co-trustees, but I also tell them, like, I want to learn a little bit about the family dynamic to make sure that there's not going to be a lot of headbutting in terms of like how to administer it, even though the trust kind of tells them what kinds of things they can do. We don't want co-trustees that we think are going to go in two separate directions. We kind of want them to be aligned. Usually you would list successor trustees. So I would tell my clients, maybe list one of your kids as the first priority. And then if they're unable or unwilling to act, it just drops down to the second kid. or something like that.
I have a general question. If you have this process where you go through those steps, do you talk to people that just have do you do like hourly work? If they just have one or two questions, they have all that stuff that you said in place, but they have questions about it. Do you handle
Yeah.
that as well?
Yeah, I do reviews a lot, especially because not a lot of attorneys kind of stay your guide for life. So I have a lot of people who come to me and they're like, I just put something together 10 years ago and I want you to review it and kind of give me your honest opinion as to whether I should update it or anything. Then I would charge for my time for reviewing it, and I usually charge $2.50 an hour, and it's probably going to take me like an hour and a half normally to review a trust and all of the documents. And then when we meet, I'm just going to tell you honestly if it's still good or if I think we should redo some of it or all of it.
Okay, thank you.
Mm-hmm.
Anastasia, the lifetime plan is a differentiator. That's nice. And are you currently the only attorney in your practice, or do you have others?
No, so I used to be just Feinberg Law. Now I'm Legacy Law Group because I merged with another firm, and he is in Fort Collins, so we kind of cover a larger area now. So it's me and him, who's my partner now, and then we have a couple of contract attorneys who may actually join the firm at some point. So yeah, if I die or if I decide to have 3 more kids and quit practicing law, you will have somebody who's going to honor your lifetime membership with the firm.
or your successor plan, one or the other, right?
Yeah.
I was going to ask that too, but I didn't have the guts.
I get that
It's
question a
begged
lot.
to be asked based on her presentation.
Yeah. All the people want to know if that lifetime membership is really going to hold up. So I have to explain that it will, but hopefully I'll be here for another 30 years or something.
Oh, more than that? You're kidding me?
I don't
working.
know. With the number of kids that I have, it's kind of hard to plan. So yeah, I'll be here for a while longer, I think.
And did you say that if you are, like some good friends of ours just did some estate planning and did name us as the guardians of their children if something should happen to them? Did you say that do we need a copy of all of that paperwork as well?
Yeah.
So if something does happen, we have that?
Yeah, because if you don't have a copy, then you can't prove that you were nominated as the guardian. And if you show up at the scene of an accident and the police asks you, well, who are you? And you tell them I'm a guardian, well, prove it. And in an emergency scenario, just pulling it up on your phone is all it takes. So you don't really need a hard copy. They can just email it to you.
Okay, great.
Anyone else? Last call. All right, well, everyone knows where to find you, Anastasia, and thank you very much. It was extremely informative. I liked your scenarios. I wasn't sleepy at all. I was like, oh, this sad Bliss family.
I know. Yeah.
I don't think I've ever had anybody explain it so well. You just really covered everything.
Oh, thank you. I'm glad you found it useful.
Very good. Thanks.
Yeah. Thank you, everyone. And hoping everyone stays well and healthy and lives for a long, long time.
Yep, me too.
All right. Take care, everyone.
Thank you.
Thanks.
All right. Bye-bye.
Thanks. Bye-bye.
Bye.